Since I occupied this office, I felt very, very encouraged to undertake my entire roles and responsibilities, knowing that I'm not alone. It's a collective responsibility. Everybody is trying to support me from whatever corner they are. And that, to me, underscores what I know about justice. It cuts across all of us. We are all interested in justice. Everybody wants to experience justice, to experience fairness, to be treated with dignity. And therefore, it is in the interest of all Kenyans that we support and build a very strong institution, a strong, independent judiciary that can serve Kenyans, not just this generation, but generations to come. Now, coming to the specific question on what strategies we will put in place to fight corruption, both real and perceived. This has been an ongoing process, even before the 2010 Constitution. Systems and structures, laws, regulations, rules of procedure have been put in place to fight corruption, because Kenyans express themselves very, very, very clearly that they do not want corruption. Every leadership that comes in office, they come on a clear platform of fighting corruption. I believe even when I was recruited as a judge 19 years ago, it was on a platform that we are coming to transform the judiciary, to fight corruption, and to make justice accessible to Kenyans. So this is a challenge, not only for the judiciary, but for Kenyans generally and collectively, for us in the judiciary, the leadership, the executive, the parliament, for all of us to come up and say, we do not want corruption, and we will not entertain corruption. We will use every means to ensure that the systems that we work with do not allow corruption to taint the justice that we deliver within the judiciary. We all have taken an oath of office, never to compromise justice, never to deal with anything other than the evidence that is before us, and never to tweak that evidence to favor anybody, or even to be influenced by anybody. So if anybody in the judiciary is practicing corruption, they know they are breaching their oath of office, it is illegal, they are committing an offense, and they are living on borrowed time. It should never happen. Cases that come to us, corruption cases that come to us, we are working with the ODPP and also the Inspector General of Police and the DCI, all these agencies that comprise the National Council on the Administration of Justice, to see to it that we effectively and efficiently prosecute and complete the corruption cases that are pending before us. I have had meetings with judicial officers serving in the anti-corruption court. I have had meetings with the NCAJ, bringing all the actors together, because you recognize that even if we are so good in the judiciary, alone we can never fight corruption. We depend on the IG under his Directorate of Criminal Investigation to conduct credible investigations, to bring witnesses in court during the hearing, and those witnesses to adduce evidence that can support the charges of criminal offenses that are before the court. We rely on the DPP, Director of Public Prosecution, to prosecute those cases effectively. In other words, read the evidence, produce the exhibits, and support the charge that is before the magistrates. On our part, we need magistrates. We need technology, because we write with our hand to record proceedings. It takes so long to go through various exhibits and you have been in those courts to follow those proceedings, you know how tedious it is. Sometimes the DPP has lined up over 50 witnesses in one case, and volumes of documents to be produced as exhibits. And the magistrate is writing with his hand, recording all those with his hand. So we are preparing to give them devices that can help them record, court recording transcription. As the proceedings are going on, there is a transcription also going on, including enabling them to get the typed proceedings immediately so that they can be able to write a judgment. So this is a multifaceted approach that we are taking to make sure that everybody within the justice sector, the NCAJ, is doing their bit. We are also trying to build a strong institution of the NCAJ by enacting an act of parliament that supports us with roles and responsibility, and including even budgetary provisions to support the multi-sector reforms that are required in each one of our agencies. Because you realize sometimes, like the DPP has so many prosecutors. He actually has 1,300 prosecutors. And this is against our 400 magistrates. So, we need a sector that is well balanced in terms of human resources, in terms of the material resources that we require, including infrastructure. During this time of COVID, you know how challenged we are to conduct in-person proceedings because some of our courts have been condemned. They don't have ventilation, so we rely on a tent mounted out there. And there are 9 or 10 magistrates, and we don't have 10 tents. We don't have, so we're really trying to see how best we can complete those cases, especially those cases that have been there for long. We've given ourselves up to the end of December to finish them. We actually haven't had mass transfers. What we had was a transfer of those who are moved from their stations. I don't think were more than 10, because as you are aware, 7 judges were promoted to the Court of Appeal. And there are judges who have been serving in one station for more than 3 years. We have a transfer policy that says after every 3 years you go to another station or another division and work from there. So it is necessary that we comply with our own transfer policy that we developed. It is necessary also that you align the skills and also to provide equity amongst ourselves. Every judge would like to serve in Nairobi because most of them are settled in Nairobi. But we have courts all over the country. All these courts belong to us Kenyans. If I'm a good judge, then even the farthest court in Vihiga or in Kware deserves a good judge to go and serve Kenyans in that corner. So this is our country. When we sign in as judges, we sign in to serve Kenyans from all corners. So there is no judge who should strictly stay in one place except if there are extraneous circumstances or they are carrying out a law that stops them from operating other than in Nairobi. Like the principal judge, of course, cannot leave Nairobi during her term. The judge representing judges at the Judicial Service Commission has to be in Nairobi because they have to combine their work as judges and that one of serving in those institutions. The magistrates similarly were transferred. In fact, those transfers were done even before I came in the office, but they were sent out just when I came in the office. They were also to respond to the transfer policy that is in place. You can't have one magistrate stay in one place for 7 years, when the transfer policy says they should be transferred after every 3 years. And there are reasons why the transfer policy was developed like that. When a judge or a magistrate stays in one station for a long time, there is familiarity, and also you want that magistrate or a judge to experience other stations and other parts of the country. It's a very, very rich experience, I can assure you, because I'm one of the judicial officers who served from Marindi to Rokichogio, and I know what a rich experience I got in serving in those far-flung places. What have I experienced in the last 100 days? Again, allow me to thank many people who have supported me in the last 100 days. Judges, my colleagues in the Supreme Court, judges, magistrates, judicial officers, the associations themselves, the professional bodies. I've had Law Society here, I've had the Chartered Institute of Arbitrators, I've had the Association of Mediators, I've had diplomatic corps, partners, World Bank, ambassadors come here to give me support, Google to give us support in digitization, very, very many people in the executive, in the parliament, all of them pledging their support for me. And therefore, I have something to share with Kenyans in the last 100 days in terms of the things that we have done that have improved access to justice collectively. This I cannot say I did it through my own might. It is through the support of Kenyans and also Almighty God, because I am a woman of faith, as I said even before. So when I was being interviewed by JSC, I was given challenges that are facing the judiciary. And I was asked, what solutions do you have? And I said, I'm a problem solver. And this is what I'm bringing to the judiciary, the attitude and boldness that I brought to this office, that I believe in solving problems, and I believe there is no problem that cannot be solved. So one of the key challenges that I faced that confronted me in this office was the serious shortage of judges. In the Court of Appeal, where we had just left with my colleague, the Honorable Mr. Justice Ouko, there were only 11 judges. And out of those 11, you can consider that at any one given time, one represents the court to the JTI as the director, the other one at the Judicial Service Commission. So we were actually almost operating below the threshold. So during the past 1 year, the 100 days, I have focused on building cohesive systems within the judiciary and building, relationship with allies and stakeholders. And, this has also brought a lot of success. My first official engagement, I think, was a visit to Kisumu Law Courts after attending the Madaraka Day celebrations on 1st June 2021. And when I visited the court, I saw how litigants were suffering. For example, the Court of Appeal sittings in Kisumu, Mombasa, and Nyeri were suspended for the last 2 years. I was taken around the registries and shown the number of appeals that were ready for hearing, but no dates could be given because of shortage of judges. At the Environment and Labour Court, the story was worse. The only judge in Kisumu was covering 3 other counties. He was sitting in Kisumu, going to Siaya, going to Jamira to hear land and environment cases. And we all know how land disputes are emotive. And this situation was replicated in many other court stations across the country. This was just a tip of the iceberg. I was concerned about the delivery of service immediately I entered this office. Inconveniences and frustrations visited on the litigants, not to mention the costs borne by the litigants of paying lawyers and of visiting the courts and visiting the lawyers' offices to inquire about their cases. So I wrote a letter to His Excellency the President and requested for an appointment and listed 3 things for discussion around the broad thematic area of administration of justice, administration of justice concerns all of us. And I asked that we will discuss the appointment of judges, budgetary allocation to the judiciary, and operationalization of the judiciary fund. I sent that letter, and I was pleasantly surprised that after just one day, a Gazette notice was issued announcing the appointment of 34 judges. 7 judges to the Court of Appeal, 18 judges to the Environment and Land Court, and 8 judges to the Employment Labor Relations Court. I was very grateful to His Excellency the President for appointing those 34 judges. But as I said publicly, it was bittersweet because 6 judges who were nominated by JSC were not appointed. So I continued pleading with His Excellency to appoint the remaining 6 judges so that this stalemate of appointment of judges can be brought to an end and we can move on to appoint more judges, because we really need about 20 judges appointed immediately so that we can be able to access justice to Kenyans. But what have you achieved in access to justice after the appointment of the 34 judges? I want to share with you, ladies and gentlemen, that now in the Court of Appeal we have 18 judges. There is a bench full-time in Kisumu and Mombasa hearing appeals, and at least 3 other benches sitting in Nairobi permanently. We also have 1 bench doing criminal matters and another bench that is doing circuit visits to Nyeri and Nakuru. That is the Court of Appeal. So we are trying to access justice now to Kenyans all over the country. In Environment and Land Court, we were able to send judges to new stations to deal with land matters in other counties where there were no judges before. And this is in Kwale, Nyamira, Isiolo, Migori, Kitui, Kilgoris, Kapsabet, and Vihiga. And also in Employment and Labor Courts, we have been able to increase the number of judges in these stations, such as Nakuru, Mombasa, and Malindi. And to me, this is enhancing access to justice. So the appointment of 34 judges within the first month of my tenure was a great milestone, because this has seen an improvement in delivery of service to Kenyans. While on this subject of appointment of judges, I need to mention this is not the first time a stalemate occurred regarding the appointment of judges by the executive when nominations have been done by the Judicial Service Commission. You will recall in 2014, Judicial Service Commission, under the chairmanship of my predecessor, Dr. Willy Mutunga, also nominated 25 judges for appointment, but there was a stalemate because only 6 judges were appointed. 11 judges were appointed after 6 months, while 14 were appointed after waiting for a period of more than a year. This is a recurring problem that has lingered on for many years that have been in this judiciary. And the question Kenyans should be asking me is what my administration will do moving forward to avoid a stalemate in future appointments. We need to understand that JSC is an independent constitutional commission with the mandate of promoting and facilitating the independence and accountability of the judiciary. In the delivery of justice, there are many stakeholders. The judiciary does not exist on its own. We exist to serve Kenyans, and the recruitment of judges must engender their confidence. Therefore, I intend to promote this accountability through consultation and dialogical discourses. The other way we have achieved in delivery of justice and access to justice is the small claims court, which were launched about 2 weeks before I took office. These courts are transformative for the justice sector as they focus the attention of the judiciary on the most immediate pressing needs of citizens. As you know, the monetary jurisdiction of this small claims court is 1 million shillings, and it has jurisdiction both for personal injury and commercial claims. In addition, cases before these courts must be concluded within 60 days. We have operationalized and equipped these courts, and we continue to support them so that they can bring justice closer to the people. Knowing how impactful these courts are and the need of our Kenyans, the vulnerable groups, small businesses, and even people involved in personal injuries, where your claim is less than $1 million. Everybody wants to go to this court and get justice within 60 days. So we engaged with the Nairobi Metropolitan Services, where they are building hospitals and doing other infrastructure to build for us more claims court across Nairobi Metropolitan Zone. And they have allocated us land, and we have approved the designs for the establishment of 5 additional small claims courts in Fuata Nyayo, Kasarani, Mathare, Dagoretti. We will have a small claims court. We are also in discussions with the various county governments through the Council of Governors. I had a very fruitful meeting with them so that we can collaborate with them to ensure the seamless rollout of these courts across the country. I'm happy to note that we shall soon, with the support of the county government of Nakuru, launch a small claims court soon in Naivasha. The statistics from these courts are truly encouraging. In the past 100 days that I've been in this office, the small claims courts have resolved 762 cases out of 1,247 cases that were filed, indicating a case clearance rate of 61%. We've also done some work in terms of clearing of backlog. As you heard, when I assumed office, this was my main concern. 651,000 cases are pending in the courts all over the country. Some of these cases have been in the system for more than 5 years. I am committed to reducing the numbers of waiting period to 3 years. My predecessor had set it to 5 years, and a lot of work has been done and a lot of success is recorded. But through the initiatives that we are embracing of active case management, I am informed by my judges and magistrates who are on the ground, because this is a collective responsibility. Everybody is taking their personal responsibility for their docket, that we can actually have cases which are only 3 years old in our system in the next 1 year or 2. A promotion of active case management standards that gives judges and judicial officers the responsibility of actively direct and the manner in which cases are handled. We are saying once the case has been filed in court, it is the court to drive that process. The litigant will have no role to play in it. We will receive the case, we will actively manage it, and if the litigant does not want it to move the speed at which we move, they will have to withdraw it. And then on the part of us, judicial officers and judges, we take personal responsibility of the docket that is before me. We are telling each other that we are chief justices of the courts that we run. If you're in a small claim court, if you are in a magistrate's court or you're in the high court, you are the chief justice of that court. So you take charge of your docket and ensure efficiency in the processes that you engage. Then we are utilizing technology to automate judicial processes to ensure efficiency. And the ICT department is developing a comprehensive ICT system that will support all aspects and functionalities of a virtual court. Many courts are now virtual. The Supreme Court is virtual. The Court of Appeal is virtual. You don't have to go to court. The other day we had a very successful hearing and very good remarks by one of the litigants who was all the way in Marindi. And we were here, and he was able to present his case sitting at his sitting room. And after finishing his submission, the judgment was delivered also online when he was in the sitting room in Marindi. So we are also working closely with the ICT ministry to extend the last mile internet connectivity to the farthest courts, and also to make sure that we can piggy ride on some of the systems that are there, like the Huduma centers, to host a desk for filing court proceedings by litigants. So I have something to say about adoption of data, because we rely on data a lot. And I spent some time yesterday with the Director of Performance Management, and he was telling me there is an increase this period of time that I've been in the office, these 3 months, there is an increase in filing of that 1%. And he said this was a mark of confidence on my leadership by the litigants. These were his words, not mine. I also put a lot of premium to the judiciary leadership teams. We have the court team, which I chair, with the principal judge and presiding judges, president of the Court of Appeal, and the representatives of all the courts. I've expanded that to include the magistrates, the Kathy, the judiciary staff, to work on the leadership, because it affects all of us. It affects all the courts. And this leadership is also now cascaded to the court level. The same team I have here in the headquarters is in every court station, and it links up with the court users committees, because the Constitution requires us to consult and to collaborate and to seek participation of the people that we serve. I'm happy to note that in the past 3 months, our core function of hearing and determination of cases has shown marked improvement, and this is the report I received from the Director Performance Directorate, that during the period from the 26th of May 2021 to 31st July 2021, a total of 77,000 cases were filed. Over the same period, 70,000 cases were resolved, and this was an indication of 87% of filed cases from the magistrates' courts, were 9% from the High Court. 81% of the cases resolved were from the Magistrates' Court, while 13% are from the High Court. August is a month of recess, so very, very little goes on. We only write judgments, rulings, and deal with urgent matters. So the average number of cases filed monthly from 26th May to 31st July increased by that 1%, Last year, similar period, they noted the cases which were filed were 29,000, but this particular period were that 8,000. This is an indicator that Kenyans have confidence in my leadership and the judiciary in general. The monthly rate of resolution of cases since I came to office has also increased. Over the same period, the case clearance rate increased from 83% on 30th June to 91% on 31st July 2021. And this can be attributed to a shared understanding and practice that judges and judicial officers are expected to take active case management and individual responsibility to assure resolution of disputes. After induction, Employment and Labor Relations Court, when we engaged the 11 judges in that court, they also increased the productivity of that court by resolving a total of 485 cases, just the new judges who are employed. So these are successes I'm happy to share, and also about supporting the court annex mediation, which we believe is going to be a game changer in addition to the small claims courts. Court annex mediation was rolled out to 21 courts. During the last 100 days, we have received 477 cases with a value of 2.5 billion, which was money resolved from those disputes and released back to the economy. And we are working hard to mainstream the tribunals. During the last 100 days, we held a workshop for all the tribunals, the people in charge of the tribunals, to really bring them on board to follow the procedures that are already set, because some of them were operating under the ministries and now they have transitioned to the judiciary. So we have to bring them on board to follow the rules and procedures that we follow in the judiciary. So I'm very, very excited about going forward, because when you ask me about the achievements, sometimes you forget what you have done and you are looking forward to what needs to be done. What needs to be done, of course, is a lot. Like this building where we are in, you can see how old it is. It was built in 1935 to support only 5 to 7 judges who were then there during the colonial time. It has been expanded beyond its remit. It has broken down some of the systems. The toilets are condemned. It leaks from the roof. We are talking about very serious digitization. There is some cabling that cannot be done in this building. So we need to build a Supreme Court, a judiciary headquarters. And my vision is to build a judiciary headquarters here, to build a judiciary training institute. As you all know, we were given notice to leave our premises in Muthaiga because they were acquired by another entity. But when during these last 100 days, I wrote a letter to the CS in charge of lands and asked for land to be allocated to the judiciary to build a judiciary training institute. I'm happy to report that we were allocated 55 acres of land in Gong, where we intend to build a state-of-the-art judiciary academy, because training is critical. It is very critical also to my vision that we have judges and magistrates and judicial officers who are well trained in the ways of managing the cases before them, in jurisprudence, setting standards, mentorship, establishing standards that are credible. We are also recruiting, as I have always shared, that the human resource register is short of about 4,000 employees across board, from judges, magistrates, clerks, secretaries, drivers, directors, everybody. We are short. So just this next week, we will be recruiting 50 magistrates and also some other establishments with the judiciary. The Judicial Service Commission, under my leadership, has embarked on a rapid resort initiative to make sure that we recruit all these key employees to fill in the vacancies. As you know, we have had support from the World Bank, where they have constructed for us 28 courts. When I came in the office, that contract was coming to an end on 31st of July, and about 10 of those courts were not completed. And I knew the burden that was going to be passed to the government and to the judiciary to complete that work. So we requested an extension of contract, and I'm happy to report it was extended to 31st of October. And we are working very hard with the Department of Building Units to follow the completion of those buildings, so that by 31st October, these projects, which we call JPIP, can be handed. All the 28 courts can be handed, completed. But those are outside Nairobi. The infrastructure in Nairobi is really in dire need of support. So we will be calling on the executive, the parliament to allocate budgetary allocations for us to be able to improve on the infrastructure. You all know of the access road that goes to the Milimani Magistrates Court. It's in a bad state. When I went there, like I told you, I'm a problem solver. I saw how the road was bad. I wrote a letter to Kenya and to the Nairobi Metropolis asking them to make the road. And I'm told today the road has been done, the road and the parking there. So the other milestone I would like to share with you is enhancing the security in the judiciary. You're all read in the papers that the judiciary has established a judiciary police unit that is led by a senior commissioner of police. When I came to this office, everywhere I went, judges in the Supreme Court told me we have no security. Even you, members of the press, you have been accessing this building. You know how easy it is. We have been sitting dark. And it's not only this court, even Milimani, all the courts, even anti-corruption, they told me, please, here are the people who come, the accused persons come with their guns in their pockets, and they enter court and we are prosecuting them. I asked for the file, and I realized that for the last 10 years we have been talking about setting up a police unit. So I took it upon myself to write to the OP and asked for a meeting with CS Dr. Matiang'i and the IG. And we had a meeting, and I put together a committee led by a Supreme Court judge, Justice Ouko, and this unit has now been set up with 3,000 police officers. Before, we used to rely on police officers being posted from Central Police to come and work here, and no one knew whether they arrived here or they did not arrive. Now it's a full-time job for our police unit and for our commissioner of police, who is in charge of our operations, just like it is in Parliament. Parliament have their own unit. Central Bank has their own unit, the railways have their own unit. So for me, that's a milestone, because there was a big stalemate over that, committee after committee. Even I saw a consultant was paid some 45 million to provide us with solutions for security. And all they recommended was, let there be a police unit, but it was never set up. So to me, this is a major milestone. The other major milestone I would like to discuss with you is the operationalization of the Judiciary Fund. It is provided for in the Constitution, and you know we can never achieve actual independence until we have budgetary independence. As long as we keep saying now we have hired 34 judges, give us money to pay their salaries, give us money to buy their cars, we have bills to pay, we have a court to build. Really, that does not engender the independence that is required in the Constitution. So we have engaged the National Treasury, the Central Bank, and the Commission on Budgeting, and we have been authorized to operationalize the Judiciary Fund. But it's a work to be done to set up a system that enables us to migrate from the IFMIS, the government IFMIS. We have to set up our own judiciary IFMIS that can support all the operations, receiving the money that we receive, paying the money that we pay out, receiving money that we receive as deposits, having a development fund. And I'm very keen on a system that is secure being set up for the judiciary. I'm very wary of migrating from IFMIS to set up a system here where money can be pilfered. We all know how money has left national coffers with gunny bags. So this is why I'm taking my time. There is a very serious technical team that is working on this, including our own directors here in finance, to build a very secure system. I'm told it will be up and running in December, but it will receive money, and we will completely transition from the IFMIS by the 2nd of July. I really want to make sure that the system we have is proper, but we have the authority to operationalize. And this is something that has been mentioned in the Judiciary Transformation Framework of 2012-2016, and also Sustaining Judiciary Transformation Framework, and it has been actualized now. But I also wish to thank my predecessors who worked on the Act of Parliament to operationalize the Judiciary Fund, and also developed the rules of procedure and regulations. I've just come in for myself to plug it, because I'm told it's like plugging on the system. So I think that is what I would like to share with you, and say we will continue collaborating with the media, because they play a key role in informing the public what the judiciary is doing. We will also continue collaborating with the NCAJ. It's a very, very important body, because although we are independent, we are also interdependent. There is very little we can achieve alone. So this coordination and collaboration across the agencies and the legal sector, working also with the RSK, a very, very key sector. EACC, they are already evaluating our systems to see that our systems are proper, because we are moving towards also ISO certification of our judiciary. So we will continue with these conversations with all the actors. The ICT ministry is critical. We also had a very useful meeting and discussions with the Kenya Commercial Bank, because they are our bankers, and they are in very many places, especially places where we are not, very far off places, and they have internet. They are very, very stable systems, digitized systems. And we were asking them, how can we have courts in those far off places? We can have small claims courts there with them. And I've also engaged in Google Kenya, and we have received already a range of financial support of $1 million to be utilized to improve access to justice. Our engagement with the county governments continue. So that we have this coordination. I've already mentioned the Nairobi Metropolis, and of course the pet subject of everybody, anti-corruption, which is a national problem that we all need to bring to an end, including the media. You have a critical role to play to make sure that our country is rid of corruption. My dream is to have Kenya, where Kenyans are empowered to know their rights, because actually it is drawn from my vision about social transformation. A society that is transformed, because we cannot talk about transformation of the judiciary alone. We must talk about transformation of the society. Kenyans who are aware of their rights, they take agency of themselves, they can solve their own problems through engagement of the various mediums we have, solving problems from the family to the community. And Chief Justice who stood up to say, let us reduce conflict in our society. Let us avoid areas and pitfalls that bring us into conflict with the law. I want to be remembered for a very independent judiciary, a judiciary that stands out like other arms of government, with a state-of-the-art judiciary and quarter, Supreme Court, that engenders trust, confidence, and faith by everybody. A court of appeal that stands out with jurisprudence that mirrors who we are, indigenous jurisprudence that solves our own problems in our own unique ways, without having to rely on common law or other, foreign precedents. We actually can rely on our own. So a judiciary that has a training institute that trains our judges, trains our magistrates. I want to be remembered as a judge who connected the judiciary and access to justice to the people. Because justice cuts across all of us, it cuts across all the people. I want every Kenyan to be asked, what is justice? And they can say what they understand to be justice for themselves. For a government to succeed, You cannot isolate one arm of the government. We must move together. So if there is tension, if there are disagreements, if there are areas that are not working, we must be able to address that. But there is something also we need to understand as Kenyans, because sometimes the executive may speak as litigants, and disgruntled litigant will say, I don't agree with this judgment, and, go on and on. This is human. Even me, if I was a litigant and I lost in court, perhaps I can say something. I say, look, the judge was corrupt, the judge did not consider my evidence. But the institution of the judiciary as an arm of government must be protected, must be respected, must be treated with dignity, because it is the one that upholds the rule of law. It is the one that protects and promotes the Constitution, and this is written in the Constitution. It is the one that upholds our democracy. We are the ones charged with the responsibility of guarding our Constitution, our law, and our democracy. So some of our decisions may not be pleasing, and that is expected. But we must be able to steer clear from that and look at the bigger picture, that we all want a strong, independent institution. I believe every president, every parliament, every Kenyan would like a strong judiciary, which is independent, which is accountable, which is uncorruptible, which is efficient, which readily resolves disputes without letting people come to court here in and out. Everybody wants that kind of judiciary. So let's work towards it. And the cream will come on top with time, because we have been implementing this constitution for the last 10 years. And many areas have been settled. So slowly we will get there, because the way I view a government is like a three-legged stool. You remove one stool, the stool falls. And I don't think any government would want that. So we have also now to internalize ourselves and know when is the litigant speaking. And we close our ears because we are used to that. And say, look, at the end of the day, we are all serving Kenyans. What do Kenyans want? They want efficiency. They want transparency in the way we render our services. They want to be consulted. They want their cases done quickly. So for me, I see no tensions. I just see possibilities of us to dialogue further, for us to come together with the executive and with the parliament and discuss administration of justice, discuss independence of the judiciary as it is in the Constitution. And for me, I have no fear at all when I'm called to such meetings, because the independence of the judiciary is protected in the Constitution. The Constitution says no party or authority or a person will interfere with decision-making, with our decision-making, with the way we hire judges. So if somebody approaches me to breach the Constitution and decide a case, I'll tell them, aren't you, excuse me, aren't you out of order? Aren't you saying something that is forbidden by the Constitution? So we, in fact, have just asked that we have a forum to discuss these issues with everybody, so that we can understand interdependence. We depend on one another. We depend on Parliament to give us budget. We depend on the executive also to ensure that there is implementation of the court orders, and so that we have to work together. For me, we have no choice but to work together, while each one of us remembering what the Constitution tells us to do and what it tells us not to do. I think the Supreme Court has settled very many areas of the law, and I think it has been unfairly criticized. For the 100 days that I've sat here, I went through induction as a Supreme Court judge, as the president of the Supreme Court, and we spent a whole week going through even the jurisprudence of this court. And I was amazed at the number of legal questions they have finalized, tackled and finalized and settled the law, especially in land cases, like group rights, ownership, evictions. You are aware of the case of Me Too Bell. In fact, I'll give you a write-up on these cases that the Supreme Court has settled on law, especially land law. There is completely settled from adverse possession to customary rights of land ownership. And these are issues that have lingered on. Now there is adequate precedent to settle all these issues. And this will help us even move with speed to resolve the land disputes that we have in this country. And thanks to the Supreme Court. You read a decision, I think, this week coming all the way from Kisumu, saying a community that has occupied a public land which was allocated to them cannot just be evicted. You cannot evict people without making alternative arrangements. This is very progressive. Also in criminal law, they have settled one area of death sentence in murder cases. Murwatetu case, which was misconstrued by the other courts and applied randomly in all other cases, including defilement and forest offenses. But we were able to give a statutory interdict to say, look, this was only in relation to murder. You cannot apply it in sexual offenses. So I think the Supreme Court, even in electoral disputes, the law is settled, especially the value of evidence, both qualitative and quantitative. And I'll give you a write-up on this because I took time for me to analyze these cases. And I can point out the areas that have been settled. The various advisory opinions that have been given to support the county, the devolution. It is because of the Supreme Court that the devolution in this country has stood, because advices have been given why everybody should respect and uphold the principle of devolution, and we cannot undermine devolution. So for me, I think that was unfair criticism of the Supreme Court. It has given the proper directions. It has handed down decisions that are precedent-setting and are settling many, many issues of law and constitutional interpretation. And we'll continue on that trajectory. Well, I think that criticism has been with us for some time. I view it as litigant speak, and unhappy litigant, a litigant who is not happy with the decision. They will describe it anyhowly. They will describe it as an illegal judgment, an activist judgment. For me, I think if you look at the meaning of the word activism, it's rather futuristic. It's speaking to the future. It's progressive. It's addressing issues of human rights, and it's addressing issues of constitutionalism and good democratic order. What I know about a judgment is that if you're not happy with it, you appeal. And they say, I'm not happy because the judge hand here. The judge made a mistake here. There was this evidence which the judge did not take into account. That is the legal way of criticizing a judgment by a judge. And a judge can because we are all human. You can fail to take into account some consideration, and therefore the result of your judgment is that there is an error. So for me, I only know a judgment which has been appealed against because the judge did not consider this or did not consider this aspect of the law and therefore arrived at an erroneous judgment. But this is just another way of opening up unfair criticism of judges and the work that they do. But I think judges are used to this. It's a new aspect of attacking their work. And I think they take it kindly that this is a litigant who is aggrieved by the outcome of the judgment. So we take it with grace and we deal with it. That raised a lot of concern, the arrest of judges, especially the manner in which they were arrested from their chambers. And I think it caused a lot of fear within the judiciary, and even out there the members of public were concerned, and it is a legitimate concern. What I want to say clearly and not to be misunderstood is that judges and magistrates, and indeed everybody working in the judiciary, including myself, we are not above the law. We are governed by the law. We should respect the law. We should respect our oath of office. We should respect our code of conduct. A judge, however, occupies a very unique position because, as we said, the Constitution has vested the power of protecting the Constitution, protecting the rule of law, protecting our democracy, protecting our institution on the judiciary. And that function is carried by a judge. So we have this judge who is a defender of the Constitution, the rule of law, defender of human rights, the one who resolves disputes. And we have this judge who can be accused of corruption and all manner of offenses, bribery, being drunk and disorderly, all the things that, because they are human. So what we are saying, if a judge is in infraction of the law, and when I say a judge, I also mean a magistrate, what do you do? Do you come to the chambers like I was sitting there, perhaps finishing a ruling to go and deliver it in court and arrest me? Will it not look like you have interfered with the independence of the judiciary? That perhaps that ruling I was going to deliver was against, somebody powerful, and therefore the only way to stop me from declaring the ruling or delivering the ruling is to arrest me. So that is something we have to guard against. And that's why I said the same way you cannot arrest a member of parliament when they are about to go and debate, or you cannot even raid the State House to go and arrest the president, the same way you cannot raid a judge's chamber or a court. In fact, we call them temples of justice, to arrest a judge or a magistrate. But should they be in infraction of the law, a judge is running nowhere. They are not a flight risk to say that unless I arrest you now, you will run away and I will never be able to catch you. And, so there are all these issues. We are not above the law. So if somebody is in infraction, let them come and tell the Judicial Service Commission is the one which is in charge of disciplinary of judges and magistrates. Say, look, we have this evidence against so and so. We believe he has breached the code of conduct and he has breached a law, criminal, penal code, whatever, or they have stolen, whatever they have done, they have killed, they have murdered. And then the JSC will look at the matter and invite the judge. And then we will see that this is really a criminal matter, you have to go answer it. And then the police will go and interview the judge, take the statement of the judge. They don't have to drag them in the police station. They can do it at the Judicial Training Institute, one room there. They can interview them there. And if they have to charge them, they charge them. If they have whatever action they have to take, or the judge can opt to, look, let me resign because I've embarrassed the office of a judge. So, this is the delicate balance we have to strike. Because of this office, constitutional responsibility that is vested in the office of a judge. And that office of a judge is carried by a human being who is doing other things. So we are working very hard. We called the CS Interior and the IG as the Judicial Service Commission so that we can work out a protocol that informs the police how they can deal with a judge or a magistrate. Because this is happening too often. In fact, I was surprised that there was such a united call. What is the Chief Justice saying about this? I said, this is not the first time it is happening. And when it happened before, I never heard such an outcry. Chief Justice say something. I started wondering, is it because I'm a woman? I said, anyway, there are more expectations of me because I'm a woman. But what I do and what I say is that I believe in processes and the systems. And when I see a problem, I look for a permanent solution that can guide us so that in future this does not happen. So we are working, a committee of the JSC and of Office of the President, to come up with a protocol or a guideline which will be subjected to public participation to see how we move forward on this. That's interesting. I wonder whether they had a problem when those positions were occupied by men. I think that is the first question to ask, because up till 2012, we were with you here, Jiro, when we joined the Court of Appeal. It was all men. All the 14 of them were men, and nobody asked a question. But let me say this. Yes, we have women who are presiding judges, but this is claim that has come on top because women have earned those positions. Judiciary is hierarchical. A senior most judge becomes the presiding judge of that court. These women judges have been here for years. Some of them have served for 40 years, over 30 years. So now they are senior. When the position of presiding happens, it happens to be a woman who is senior most. Therefore, they take the position. But that does not mean that judiciary is not, judiciary is an equal opportunity employer, according to the Constitution. We still have more men in senior positions than women in the judiciary. Look at the Supreme Court. We have 4 men, 3 women. Look at the Court of Appeal. Out of those 18 judges, there are more men than women. The High Court, the same. There are more men than women. Chief magistrates, there are more men than women, including even principal magistrates, until you get to the resident magistrates. Those are the ones who become now more the lower cadres. But the judiciary has employed an equal opportunity principle in the recruitment. In all the recruitment we do at the Judicial Service Commission, we ensure that there is gender parity. Now we are receiving more applications for the resident magistrates from women than from men. But we deliberately ensure that the men will also be a that. Yes. Yeah, so that is really unfair criticism, because nobody complained when these positions were occupied by men. And the women have earned these promotions as of right. Well, as judges, we don't look so much in the future, we look at today. By the way, we live day by day, and that is by virtue of our training. I'm here as the Chief Justice today, dealing with these problems. I give them my best. I deal with them according to the law. My tenure of office is protected by the Constitution. So if it happens that another regime comes as it will, I will deal with it according to the Constitution and according to the law. We are independent, we are impartial, we have no preference, we are completely apolitical. We just deal with people systems as they come. So if a new system comes and they bring a dispute here in court, we deal with it according to the Constitution and according to the law. We deliver our judgment. And then we wait for another case to come. That's how we deal with matters. We wait for one case after another to come and they deal with those cases. So I may never be able to speak to the future. I can only speak for today when I'm in the office and say I'm independent, I'm impartial, I have no biases whatsoever against or for anybody. I am completely apolitical. What happens there for me until they bring it here and reduce it into a legal problem or a constitutional problem, I am never bothered. My leadership or my administration is really centered on the people, especially the employees. To me, they are my most critical asset. So I'm completely committed to work towards improving their terms of office, their terms of pay, the work conditions. But there is something about money which I know everybody also, including you journalists, know. You can never have enough of it. So even if your pay is doubled, it may never really sort all your problems. We just have to continuously continue engaging on how we value the service that we deliver and how we organize our financial situations to be able to live within our means, the salaries that we earn, because we also understand we are operating under a very difficult economy that has been ravaged by the pandemic, COVID-19, and we should always be grateful as judicial officers, magistrates. We have a salary that hits our account every month. Many Kenyans have lost their jobs. They have lost their businesses. So when Salaries Remuneration Commission tells us, we will not review your salaries, we must be understanding that they are not refusing. They are not looking down upon us. It's simply that the economy cannot support. And I urge, my colleagues, let us understand that our economy, our country, it's just like your mother. You know how much your mother is able to give you.